Welcome to this presentation in which we're going to begin the discussion of privacy and what the responsibilities are with respect to employers and their interactions with employees. What privacy rights do employees have? So let's begin. We're going to discuss today kind of an introduction to the topic of privacy, and then we're going to explore a really, really important term, perhaps the most important term in this module, which is the concept of a reasonable expectation of privacy. We'll touch briefly upon constitutional and statutory issues. So let's begin. Obviously, there's a lot of information that employers have about their employees. This information has dramatically increased in the last 30 years. When I started practicing in 1990, and it was the responsibility of the litigants to exchange information through the discovery process. And let's say I was representing the defendant or the employer. Well, the employee or the plaintiff would typically ask for a variety of personnel files, his or her own personnel file, often the manager's personnel file, and perhaps comparators, employees who were in a similar situation to the employee. And so these personnel files would be requested. Uh, and of course, the law would require that the employer give up that information. When I first started practicing, I might be sharing one banker's box, maybe two or three banker's boxes in a relatively big case of personnel files. Each personnel file was probably anywhere from a few pages to perhaps 2 inches thick. To have a personnel file of 3 inches would be really unusual and would reflect somebody who had been employed for a very, very long time. And that was pretty much what there was provided to the other side. Nowadays, that same situation where the employee wants his or her own personnel file or any other related information that would you might ordinarily think would go into a personnel file. That same level of information would take several bankers' boxes, possibly dozens of bankers' boxes. It could include all of the emails that employee sent, all the emails that he or she received, every single time they were entered into a database by the employer, or perhaps that they entered their own information into a database, every single click that they made on their computer. It could be a huge amount of data. And so, of course, an issue comes up is what should the employer do with this data? Obviously, most of it nobody ever looks at. The keystrokes that I do on my computer at work, most of the time my employer wouldn't really care one way or the other about it. They would be a tremendous amount of information, and it would be hard, frankly, for the employer to even make sense of it. But certainly, from a forensic standpoint, if I'm being charged with a crime, that data could become very, very important, and it could have other significance to a particular case. So these types of inquiries have gone from being a relatively straightforward sharing of information, not too many pieces of the information being very controversial, to having pitch battles about this type of information. One of the reasons why we have pitch battles over this information is because collecting this data and presenting this data in a way that's going to make sense can be tremendously expensive and time consuming. This is the whole topic of e-discovery, and this is, fortunately for us, not a course about e-discovery, but I wanted to flag that issue because that issue is lurking behind the discussion of privacy issues. E-discovery is about privacy, but it's also about the expense and time that is involved in sharing this information. So this is a really, really timely issue. As employers have more and more information about employees, how that employer can use that information, can store that information, can share that information becomes more and more important. So, what is privacy? Privacy, sometimes people say, is the right to be left alone, the right to have a sphere in which The person controls who has access to the information. Generally speaking, privacy isn't something the law has a lot of interest in. Historically, we all had our own zones of privacy kind of innately. Go back to the Middle Ages, there was no way that the government knew what was going on in my house because it had no way of knowing. I mean, I guess it could put one of its agents, its ear against the wall of my house and perhaps overhear conversations or perhaps have people hiding under an eave, the eavesdropper, so to speak. But honestly, there wasn't a lot of that because it was very human intensive and it was difficult to do. And so as a result, people just assumed that what was happening in their house was really their own private affair. Nowadays, though, of course, there is the great potential for people's private zone to no longer be private. We've seen in authoritarian and totalitarian countries that oftentimes, I'm thinking about when the Soviet Union existed, and certainly in countries like Iraq and North Korea today, that we see, um, not Iraq today necessarily, but I mean Iraq during Saddam Hussein's era, that we see that the technologies, the bugs in dissidents' homes and things along those lines resulted in the government knowing every single word people said, even in their most private locations. And certainly that technology exists in the United States, even though it would be unlawful in most cases for the government or for private entities to use it. But the power exists. Well, not surprisingly, since the common law developed in a pre technological world, there wasn't nearly as much concern about privacy because privacy was a given. Privacy was an automatic situation. Where we see privacy being a concern in the United States is with respect to government action. So when the government is invading our privacy, we do see that the Constitution and statutory law often do protect us. Even in a pre technological world, there was still the possibility of having, for example, government soldiers stationed in our homes, the quartering of government officials in our homes, and that's one of the reasons we have that constitutional protection. So, most of our statutory and constitutional protections that we're going to be talking about are going to relate to the government and its requirements to protect or to not invade our privacy. And an important case in this area, although it's not directly related to employment, is the Griswold case. This actually is a line of cases that really, this is the first in the line of cases that led to Roe v. Wade. And this is the idea. I'm not going to go through extensively in this case, but this is the idea that there is a part in everyone's life that the government really can't intrude upon. And that in this area, the government really should mind its own business, so to speak. The Griswold case had to do with a married couple's use of birth control in the privacy of their own home. And the idea is the government can't get involved in that decision and that activity. That would be an intrusion into the couple's private life, and that would be unconstitutional. And yet, if you look in the Constitution, you won't see anything about there are no words in the Constitution that suggest that the federal government can't restrict a married couple's use of birth control. Just doesn't exist. And in fact, many constitutional scholars would say because it doesn't exist, that isn't a protected right. But in 1965, the Supreme Court held that it was a right. And what they did is they looked at the penumbra of the Bill of Rights. And we'll talk more about this word later on. But this is an idea that you can look beyond the actual words in the Constitution and look at the rationale behind those words and then apply that rationale more broadly. Because after all, in the late 1700s, I mean, there wasn't much in the way of effective birth control. And so it's not surprising that the founding fathers weren't really focused on protecting a right in that place since that technology didn't really exist in a way that we see it in 1965. Again, we'll talk more about penumbra later on. Sometimes there can be issues of an employer having some legitimate concerns about what's happening in the workplace. Am I being productive at work, or am I surfing on the internet? Am I sharing my employer's secrets with perhaps a competitor? Am I looking at pornography or going to websites that have inappropriate contact, content? Excuse me. Am I saying things to the customers that the employer would prefer that I not say? All of those things are legitimate things for an employer to be concerned about, and yet you can see how there's privacy concerns too. What maybe I'm, instead of looking at pornography, maybe I'm looking at the pictures of my newborn baby. Uh, does the government, I mean, excuse me, does the employer have an interest in the private pictures I might have up on my screen? Uh, Maybe instead of me going to inappropriate websites, I'm checking out some medical information that I just received from my doctor, and I want to Google, and he's maybe shared with me that I have this diagnosis or that diagnosis, and I want to Google to see what that diagnosis means. Is that information my employer ought to have? You can see how there can be competing interests in those circumstances between a legitimate concern that the employee has about his or her privacy, but also an interest that the employer has in making sure that I'm being productive in work and not doing something excuse me, excuse me, harmful to the interests of the employer while at work. Another thing to consider is that privacy law varies dramatically between country to country. And many countries have much greater privacy protections than we enjoy in the United States. And so, an employer that is based in several locations may have to look at those issues in different ways in different spots. Um, Even when the employer does gather the information, the employer may have responsibilities about how it stores that information, how it uses the information, how it shares that information. So there are actually several points along that line of what happens to the information that the employer has to be aware of. Not surprisingly, employers don't have an absolute right to privacy in the workplace. This even includes government employees. What we're going to see is there's a balancing of the interest, and we're going to see when the employee employment is governmental that the balance is more in favor of the employee than when the employee is employed by a private organization, such as a corporation. There's still a balancing of interest, but the balance is going to be significantly more in favor of the private employer. Um, there is no state law, there is no comprehensive federal law that's going to protect us from workplace privacy, especially when we are employed by a private entity. Uh, there really aren't a lot of protections in Texas. There's going to be some common law protections, which we'll talk about in this a series of presentations, but we're not going to find statutory protections. We will talk about a few federal statutory protections, but they don't apply broadly, and they are not going to be, in most cases, of significant benefit to private employees when there are privacy concerns. And of course, we will talk about the Constitution, but just a little reminder, whenever we talk about the federal Constitution, the U.S. Constitution, in other words, we're just talking about government action. That's what the public is protected from when the government acts. No matter how evil a private corporation is, it's impossible for that private organization to violate a person's constitutional rights because the constitutional rights relate only to what the government cannot do to a person. Again, obviously, if you're employed by the state or federal or local government, then there can be constitutional issues in play. We've already talked about employment at will, but this is important to be refreshed about, I think. And that is when an employee takes an action or does something and the employer finds out about it, if the employer wants to fire the employee over that, in the vast majority of cases, there are no limitations on that. Again, unless it's an illegal reason. But we'll talk about in the privacy area, there's not a lot of areas where there's going to be that protection. So obviously, if I am during my lunch hour checking the internet about, well, let's say I'm looking at it for Black Lives Matter, maybe that's a cause that's very important to me, and my employer finds out about that and decides to dismiss me because of my involvement in Black Lives Matter. Well, if I am African American, I very likely will have an argument that that's racial discrimination. But if I'm Caucasian, I could have an associational argument saying that because I am associated with African Americans who are involved in the Black Lives Matter movement, that I would be able to assert a associational race discrimination claim. But if I were instead looking up cookie recipes during my lunch hour and the employer just didn't like me looking up cookie recipes, I'm not going to have any protection in that situation. So there aren't a lot of non protected, kind of obviously connected to protected uh, characteristics, privacy violations that are going to really give me a claim and give me protection if I'm employed by a private entity because of this at will protection that the employer and the employee enjoy. Our main area, if we're involved in private employment, our main area of protection is going to be the common law. But as I already said, the common law really, quote unquote, grew up in a pre technological era. And so we're going to see that it's really hasn't fully adjusted to the world that we currently live in, where there's so much data about every individual. Um, there are some differences in different states. Not surprisingly, California is um, the kind of outlier in this area, as oftentimes happens. California is often the outlier in areas of employment law. And this has to do with the state constitution. The state constitution has broad protections for employees in California. So if you are practicing in California or you are practicing in Texas, and the clients with whom you are working happen to have employees who are based in California, you'll see that there are significant differences to the analysis that I'm going to share today. In fact, I would say to you, pretty much ignore most of what I say today. I'm not going to give a treatise in California law because it's not directly relevant to obviously Texas employers. But there are many surprises in how that law happens. And this is just one example. There is actual protections under the state constitution of California that give privacy rights to employees even with private employers. In fact, a California employee has protections related to his or her personnel file that are pretty significant in California. Now, obviously, Texas does not have these protections, and so they won't apply if the employee is employed in Texas, even if that particular Texan works for a California based employer. It will, however, apply if a Californian is in California and is working for a Texas based corporation or a California based corporation or really a corporation that's based anywhere in uh, the United States or abroad. Now, a Texan who is traveling to California and who something happens while he or she is on a business trip, for example, in California, uh, potentially could advance some California theories, but they would have to be in physically the state of California for that to work. So as a result, we're not going to spend really any time on California law. I just wanted to flag it because there are lots of interesting and quite controversial protections of privacy in California. Let's talk about the concept of reasonable expectation of privacy. I'll probably mention this topic, I don't know, a dozen times over this presentation. It is really important, and it probably doesn't mean what it sounds like it means. So, the concept of a reasonable expectation of privacy, the first thing that we see in this word is the word reasonable. And of course, in this context, whenever you see the word reasonable in a legal term, Think about the reasonable person or the reasonable man concept. And again, if you're not familiar with this term, let me give you a little bit of a refresher. The reasonable man, and that may sound a little sexist, but that's again the common law developed in a pre-feminist world. And so when people use the term reasonable man, they didn't really mean a reasonable male, they meant a reasonable human being. But the term man once upon a time had a broader meaning. It could include mankind, for example, or humankind. And so the reasonable man was about this hypothetical person who was very typical. He or she wasn't smarter than average, wasn't dumber than average, wasn't better educated than average, wasn't less educated than average, wasn't more sophisticated or more urban than average, wasn't less sophisticated or less urban than average. It was just the typical person, John Doe or Jane Doe, just a common average person. And uh, the idea was this was kind of your typical ordinary person. This person didn't have the quirks that each one of us has. I'll give you an example. A quirk about me is I cannot stand, I mean, close to uh, can't be in the room with somebody eating french fries. To me, the smell is so repugnant. It makes me physically ill. I love potato chips. I love lots of junk food like mashed potatoes, but French fries are just such an offensive smell to me that if somebody is eating it in a car with me, I can't stay in the car. It's that type of very, very awful, awful smell. Um, but that's not typical. That's a quirk with me. And even though I don't understand how y'all eat those French fries, I understand because I've been around enough people to know that many people find the taste of French fries not incredibly gross. And they actually don't have to be paid lots and lots of money before they're willing to eat a French fry. They, in fact, I understand to be the case, enjoy the taste of the French fry. Even though I completely don't understand that, I have enough life experience to recognize that the average person actually thinks a French fry tastes okay. So I'm not a reasonable person when it comes to French fries. I have this quirk. In lots of other areas, I might be a perfectly reasonable person. But if I'm a plaintiff in a case and the case has to do with French fries, the court is not going to say I'm a reasonable person. No, the jury's not going to say I'm a reasonable person. They're going to say Groover has a weird quirk, and that makes her unreasonable in this area. But the truth is, we all have a quirk like that, and most of us have many quirks like that. And so when we consider a reasonable person, we strip away all of the strangeness that each one of us has. The particular foods we won't eat, the particular smells that turn our stomach, the particular interests that the average person just doesn't have. And we just look at the typical person, the reasonable person, the person who represents kind of the average in society. And so when we're considering the reasonable expectation of privacy, we're not looking at a particular individual and say, well, what did he think was reasonable? Because that particular individual might have a quirk. He might think it's reasonable that his boss never come into his office and never look at anything that he produces. That might be his quirky belief about what's reasonable. But of course, that wouldn't be what the average person would think was reasonable. The average person would think, well, yeah, we all probably are entitled to a little bit of privacy at work, but we're on the boss's payroll, and the boss is paying us, and so probably the boss has some reasonable interest in knowing what we're up to. And so that's the concept of reasonable in this context. So we don't just think about what the plaintiff thinks is reasonable. We think about what, on average, people in this society would consider. And this is the standard. Was that particular employee's expectation of privacy in that particular situation reasonable under the circumstances? So the question isn't, did that person genuinely have an expectation of privacy? No. That person could have a quirky belief that was not based upon facts, kind of like my quirky reaction to French fries. And that's not the standard. The next word that we have here is expectation. So, an expectation develops because of experiences a person has. When I see a package that has colorful paper on it, all around it, and that it is under a spruce tree that has lots of tinsel and colorful balls on it, and we're in the month of December, my expectation is that that box contains a present because that has all the trappings of Christmas and a Christmas present. That's my expectation. But if that same scenario were presented to somebody in, say, 1000 BC, that person would have no notion of Christmas or Christmas presents. After all, Christ hasn't been born yet. And so uh, the expectation that I have is tied to the culture and to the life experiences that I have had. And so you can't divorce the reasonable expectation of privacy from the larger culture. And this culture can be specific to a particular company. So, how does this company handle privacy matters? And one of the things that we'll see is that it's so important in this area is that companies create these expectations. Companies are constantly telling us what they will and will not do. Uh, this is, one of the things that I'm sure you typically get because I get them all the time, are updates to the privacy policies of various companies with whom I interact. Maybe it's Amazon, maybe it's Apple, maybe it's um, my cell phone company, and they will tell me in these documents what I can expect this company to do with my private information. I mean, if you're like me, I don't, yeah, I don't read those. I don't think too many of us do read those. But the expectation is under the law that if I've received it, that I've read it, and that I'm going to change my behavior based upon it if I don't like what it says. That may not be reasonable because it doesn't actually happen in the real world, but that's the idea. If I read Amazon's change in its privacy policy and I look at it and go, I don't like this very much, I'm going to cancel my Amazon Prime account and I'm no longer going to shop at Amazon and I'm not going to use my Kindle anymore. Um, that is what I'm supposed to do if I don't agree with the expectation. But if I either read it and or maybe I don't read it and I go about interacting with Amazon just as I had been before, and Amazon does something with my private information that I don't care for, I'm not going to have a very good basis to complain about it because the court's going to say, you knew what Amazon was going to do, or at least you had the opportunity to know, and maybe you chose not to, but you could have, and you continued using it. And a reasonable person would have read that and discontinued using the Amazon service once that person realized that Amazon was going to do something with that information that the person didn't want. So, one of the things that we see that employers do is communicate to employees how the employer is going to use all that private information. And that information is going to be the basis of whether the employee has a reasonable expectation of privacy in the work. So, again, employers are going to establish lots of privacy policies and they're going to communicate those to employees. When I was at JCPenney, we would send out it wasn't an email, but it was something that would pop up on the computer as the employee was logging in one day to work. And the employee had to click beyond that in order to get into his or her workstation to the computer that he or she worked at. And that would be the whole policy that we had with respect to that all employment. Did the employees typically read that carefully? I certainly didn't, even though I was involved in drafting it. I mean, I read it because I was drafting it, but I wouldn't have read it otherwise. And when I was in my employee mode, I wasn't reading it. I would kind of glance at it. Oh, yeah, this is a boring privacy policy. Let me click on and get to my work. That's how most people react to that. But once I had the opportunity to see that, and typically employers do this once a year. They may do it via an email. They may do this through an employee handbook, or they may do it through some kind of screen that pops up as the employee is at his or her terminal. But once the employee has seen it, then the employee can't say, well, I didn't know what the rules were. I didn't know what my reasonable expectations were. You've been told now. Whether you chose to read it or not is your choice. But now you know what the expectation is going to be. If the employee continues that employment relationship after having been informed about that policy, then the employer has relinquished his or her privacy in that area. He or she has waived it. There's been a waiver of this right. And what is a waiver? It's the intentional relinquishment of a known right. Of course, when we use it in a verb form, we take the waiver form. This word is the noun form. If we remove the R, we have the verb form. Away, I waive my rights. I give up my rights. If you don't have this yet in your Quizlet, I would suggest that you add it to your Quizlet. So the employee who doesn't immediately resign upon looking at this privacy policy has waived any rejection of this policy, or is very likely he or she has waived any rejection of the policy because he or she had the opportunity to review it and the opportunity then to end the employment. So continuing the employment when the person has the access to that information would qualify as a waiver. And so if the employer does something with that information after that time, the employee doesn't have a basis most likely for objecting to it, especially when the employer is a private entity. So let's consider this whole reasonable idea. So generally, an employee has a reasonable expectation that his body and his physical space are private. So an employer typically can't search an employee's body, can't say, I want to frisk you down. Or I want to intrude upon your physical space and check your pockets, for example, or check inside your shoes. Those would be areas that generally there would be a reasonable expectation of privacy for. But let's say an employer, for we'll say legitimate reasons, might say, well, let's say the employer is a diamond company, and the employees handle diamonds as part of the workplace. Well, those would be very easy to secret in one's mouth or one's clothing, one's pocket, one's shoe. And so, in that situation, it might well be a reasonable expectation that the employer might pat down employees as they leave. But the employer should inform the employee on the first day of work before the employee is exposed to any diamonds. Hey, you're going to be dealing with some very expensive things, and if you walk out of here with a 5 carat diamond, I mean that's a heck of a lot of money, and that would be easy to hide in your mouth or somewhere else. And so, we're going to be, you know, patting you down. We're going to be checking to make sure you don't have that diamond on you. And under those circumstances, that would be a reasonable situation, I would think. But if my job is being a paralegal in a law office, it's difficult to imagine that there's going to be a reasonable expectation that I need to be patted down at work. I mean, maybe I'm carrying out a stapler, maybe I'm carrying out something like that. I mean, I suppose I could have a thumb drive with private information on it. So I'm not saying that it would be impossible to imagine an employment situation where I could be subject to that type of intrusion. But I would certainly need to be told that that could be an expectation that could happen in the workplace. An employee has a reasonable expectation about private locations, such as a purse or a briefcase or the bathroom. I should have the right to be able to be in the bathroom privately without anyone observing me. Now, one area where this might not occur is when drug testing happens. And so I may be required to provide a urine sample when I'm being observed so that it is, in fact, my urine. I don't have some urine secreted on me that may not have any kind of tainting of drugs in it if I think I might be subject to being tested positive. So there are some times where even reasonable expectation of privacy might not be present, even in places like bathrooms. But again, the employer is going to make it very clear to that employee, hey, if you continue your employment, When you are subject to a drug test, you're going to have to be present with another person, and typically in this situation, be a person of the same gender, while the urine sample is obtained. Similarly, employees who are subject to purse checks or briefcase checks or locker checks would need to be notified about that. Let me give you an example. When I was at J.C. Penney, many styling salons would, for one thing about stylists is stylists use their own equipment. They use their own scissors and oftentimes their own hair dryer or blow dryer and other items. Um, it's kind of their own specialized equipment for their work performance. And so the workers oftentimes carry these supplies to and from work with them, and employers in the styling salon industry oftentimes require that these satchels be clear so that it's obvious what's leaving the facility and what's coming into the facility. So the employee, for example, can't be taking out other people's scissors or other people's blow dryers or various styling products that might be quite expensive. Because the bag is clear, then it's literally transparent what the person is taking out or bringing in. And so, under those circumstances, it's very obvious that that employee does not have a reasonable expectation of privacy because the bag that he or she is required to use is transparent. And so, that's one way of approaching this issue. There are other situations where an employer may require that purses are always checked going in and out of a facility, or maybe backpacks or lunch satchels or lunch bags, things like that are always checked, going in and or going out. In that situation, there is no reasonable expectation of privacy because you know and you're told on that first day at work, hey, if you bring this into the facility, on its way out, we're going to require that you open it up and that we look inside it. And so, under those circumstances, the employee isn't going to have a reasonable expectation of privacy. So, usually, the reasonable expectation of privacy becomes an issue when there's a change in the policy, when the employer hasn't been checking satchels in and out of the building and suddenly starts. And under those circumstances, the smart employer is going to have a communication that's very clear, that's shared with each worker. This is how things are going to be going forward. And even if it's not every single satchel being checked, that there's a random process, every 10th satchel or something along those lines, um, that the employees see that it does happen and that people are not chosen on purpose. For example, Mary's satchel never gets checked, but Bob's satchel always gets checked. That's the type of thing that would be problematic from a privacy standpoint. And again, similarly, employees have a reasonable expectation of privacy about their personal information, their health information, for example. Again, if it's accessed without permission. Again, this is going to go back to what the employer's policies are. The employer may well require that you share your passwords with the employer. And that again can be part of that employer's policies. And obviously, if you know that the employer has your passwords, and you know the employer has access to that, so you obviously would not have a reasonable expectation of privacy under those circumstances. Let's consider this case. This isn't an important case, but I think it gives some insight as to this whole idea of a reasonable expectation of privacy. This is a case that arose out of the First Circuit, but I'm sure the Fifth Circuit, our circuit, the circuit that covers Texas, Louisiana, Mississippi, would reach a similar result. Puerto Rico is in the First Circuit, even though the First Circuit is mainly in the northwest. Puerto Rico, weirdly, is kind of covered by that. So in this case, the employer, which was the telephone company, had a continuous video surveillance over all of the workers in a very large room. So all the workers knew that the camera was very obvious and had been communicated that it was there. All the workers knew that 100% of their time working, they were going to be observed with these video cameras. And these employees alleged that it was an unreasonable search of them prohibited by the First Amendment. Now, one of the interesting things about this company is that it was a quasi public company um, because it was a public utility. And public utilities are a little bit like um, uh, government entities. Because at least at one point, the um, you had to use everybody in that particular jurisdiction had to that area had to use that particular utility company in order to get whatever that service was. In this case, the appellate court said no, they did not have an objectively reasonable expectation of privacy because they could see the cameras. They knew there was no privacy. So, how could they expect there to be privacy when they could see the camera pointed right at them? And so, under those circumstances, their privacy rights were not being invaded. It was obvious they had no privacy. They may felt that it was unfair that they had no privacy, but they didn't expect there to be privacy when there obviously was no privacy. As we said before, privacy can be protected by the Constitution, either the state or the federal Constitution. Again, this is going to not apply to private employers, at least in Texas. We can also look to federal or state statutes. Again, in Texas, we're not really going to see state statutes, so we're going to be focusing on federal statutes. And then we'll also talk about common law principles. As we know, the common law is not identical in all 50 states. Generally speaking, there are concepts that we see in states from one state to another, and there's a lot of commonality in the common law from one state to another, but there also can be important differences. An important idea when we talk about privacy law is the concept of a fundamental right. And when we use the term fundamental right, again, it's a good Quizlet term, is that we're talking about the U.S. Constitution. Is this one of those basic rights that people died during the revolution to support our rights in these areas? Is this something that our Constitution is focused on? And that idea of a fundamental right is where we're going to see privacy pop up. Now, privacy, again, is not literally mentioned in the Constitution, but the idea of a privacy right, in many cases, in that the U.S. Supreme Court has interpreted the Constitution, has found that privacy was really what was going on in the minds of our founding fathers at that time. And so, even though it's not explicit, it is still a fundamental right, again, with respect to governmental action. So now we've explored the idea of a reasonable expectation of privacy. I hope that you've gotten the idea that when you're employed by a private entity, the private entity, the employer in that situation, is really shaping what the reasonable expectation of privacy is. If the camera is obvious, you don't have a reasonable expectation of privacy. If the employee had access to the privacy policy of the employer, and the employer has actually followed that policy, it's very unlikely that the employee has a reasonable expectation of privacy. So a lot of this goes back to the idea of just being transparent with the employee. And so if the client is being clear, transparent, sharing what it's going to do, and is consistent with that, in most cases, the employer is going to be okay from any kind of lawsuit from the employee based upon an alleged privacy violation. Let's consider some constitutional issues. And again, we're focusing on government employment here. So obviously, if the government is the employer, the government has to follow the Constitution. A term for government employment is working for the public sector. Again, if you don't have this term in your Quizlet, please add it. This is the sector of the workforce represented by governmental employers and government agency employers. So if you work for the state government, the federal government, even the local government, you are in the public sector. So public employees, government employees, public sector employees, whichever term you want to use, do enjoy some privacy rights with respect to their employment. And they have that through the Fourth Amendment, and we'll also see through the Fifth and 14th Amendment in some cases. And the Fourth Amendment prohibits unreasonable searches and seizures. Now, this is not, of course, keyword here is unreasonable. So they are not they can be subject, public employees can be subject to reasonable searches and seizures. And it is not always necessary that there be a search warrant for a public employee to be searched at work. So these rights are not without limitation. Let's just glance at, oops, sorry, at the Fourth Amendment so we can see what we're talking about when we talk about the Fourth Amendment. So this is the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, we're mainly talking about non warrant situations. And so the people we're talking about here are the public sector employees. And this constitutional protection does apply to public sector employees even when they are at work, working for the governmental entity. So this is the protection that applies. Again, it doesn't apply to private sector employees unless, of course, the government is coming into the workplace and searching. But when it's the private employer that's searching, there is no protection under that circumstance under the Fourth Amendment. Um, here's a little bit of a clarification. A search of a government employee's office by a supervisor. So this is again somebody who also works for the government. So this counts as the government doing it, will be justified at its inception when there are reasonable grounds for suspecting that the search will turn up evidence that the employee is guilty of misconduct. Keep in mind, it doesn't have to be unlawful behavior. It might be perfectly lawful, but it's misconduct in terms of this particular workplace. The person isn't supposed to um, to shop um, during the workday. The employee that there's reasonable grounds for the employer to think this employee was uh, searching, say on Amazon for personal things during the workday. Nothing illegal about that. Hasn't violated any laws at all, but they violated the workplace rules that existed. And so the supervisor in the situation could reasonably check that employee's history of where they have traveled on the internet to see, are they going to Amazon, and that would be an indication of work related misconduct. Now again, there has to be reasonable grounds. In this situation, the supervisor wouldn't be able to search all the employees. Well, I imagine somebody's doing that, unless there was this reasonable grounds to suspect a particular employee. Now, again, this all relates to government work. If the employee is employed by a private entity, there wouldn't be no requirement that there be reasonable grounds under those circumstances. So, obviously, if you have to have a reasonable grounds or there has to be a reasonable basis, if the search is unreasonable under the circumstances, then there could be a violation of the Fourth Amendment. And so, how could it be unreasonable? Well, one thing, it could be unjustified at its inception, at its beginning. In other words, when that supervisor started looking, he or she did not have a reasonable basis to start looking. So, his or her decision to start looking at the beginning was unjustified, was unreasonable. A second way that can become unreasonable if the scope is larger. For example, let's say that the supervisor had reason to think that the employee had done this yesterday. That several workers had come to the supervisor and said, "Hey, I went by Bob's office and I could see he was surfing on Amazon on his computer during the workday, and I just want to let you know about that." And let's say three different employees come to the supervisor with that information, but it all related to Tuesday afternoon. Um, and so the supervisor would be reasonable to search uh, Bob's, web traffic on Tuesday afternoon. But let's say the supervisor searches that time and doesn't find anything. So maybe the supervisor thinks, well, gosh, let me search 2 weeks ago. Let's see what Bob was doing then. That may well be impermissible because it's beyond the scope of what was reasonable given the information that the supervisor had. So it can be unreasonable because there was no basis to start, or it can become too broad, and it can become unreasonable when it gets too broad at that point. So let's consider this scenario. Mary works for the county, so she works for the government. In this case, it's not the federal government, but it is a branch of a government entity. Her supervisor receives information from a credible source that Mary has engaged in food stamp fraud. She's using her position to um, profit unlawfully as a result of that. She's fired after Bob searches her office and finds this evidence against her. Under these circumstances, Mary's not going to have any recourse under the Fourth Amendment because Bob had reasonable grounds for to suspect, and he engaged in a reasonable search. Um, and that reasonable search led to the information that resulted in Mary being discharged. Let's consider this circumstance. Does the state employee have an expectation of privacy in his office desk? And the answer is sometimes he does and sometimes he doesn't. Okay, here we're talking about a state employee. This is a doctor at a psychiatric hospital. He was placed on leave because some of his activities were not perceived of as appropriate. They decide to search his office after he's on leave, and they seize both some of his personal items as well as state owned items. He is dismissed from his position and he's sued, saying the search violated his Fourth Amendment rights. It went to the Supreme Court, and the Supreme Court said yes, potentially the doctor did have a reasonable expectation of privacy with respect to his desk and cabinets. And so the question is, was that reasonable expectation violated? But it at least exists conceptually. And again, the case was remanded. This means sent back to the trial court so the trial court could listen to evidence and reach a decision about whether, under the light of the totality of the circumstances, the doctor's expectation of privacy was reasonable in this particular case. Let me give you an example. Something on top of a desk, you wouldn't really have a reasonable expectation of privacy for because anybody who walks into the office could see it. An office that doesn't have a locked door, maybe doesn't have a door at all, would have less of a reasonable expectation of privacy than an office with a door, and especially an office with a door with a lock that the employee has the key to. And the best case would be, and no one else has a key to it. A filing cabinet that the employee has the key to, and as far as the employee knows, is the only person that has a key to, there would be a higher expectation of privacy than a filing cabinet that doesn't have a lock on it. Um, the prior practices of this hospital in terms of when it would allow or when it would engage in searches. If the doctor knew that this happened pretty commonly, that offices were searched, then his or her reasonable expectation of privacy would be significantly lower. If this had never happened at all, then his or her expectations would be relatively high. So you see, you have to have a lot of evidence in order to decide where that line is. And that's why it was sent back to the trial court. So the trial court could hear that testimony and reach a decision about whether the doctor's expectations of privacy were reasonable. Now, notice this isn't about what the doctor actually thought. He may have thought that his office was completely private and they would have no legal basis for doing it. His subjective, quirky beliefs about privacy aren't what the trial courts are going to try to ascertain. Instead, it's what a reasonable person in the doctor's situation would think. Um, a search warrant can sometimes be required. An exception could be if there's a strong government interest and if there is a lot of regulation in the industry. And again, we're still talking about government employment. So if there's a lot of regulation in the industry, the government employees already have the idea that there's a lot of checks and a lot of controls in that particular industry. And so therefore their reasonable expectation of privacy is less than it otherwise would be. And then, of course, there's that balancing of interests. For example, railroad workers, we don't want them to be intoxicated, right? Because they could be in a safety sensitive position, and if they're intoxicated, the people riding on the trains or the people in that community could be at significant risk if the train is derailed. And so, under those circumstances, it seems pretty reasonable to have drug testing under those circumstances. On the other hand, a receptionist in an office building somewhere, even if he or she is intoxicated, there probably isn't a lot of very dangerous things he or she can do in an intoxicated state as a receptionist. So the legitimate interest for having that balancing test just would not be the same as for safety sensitive folks. A search of an employer-owned property, a written policy can absolutely reduce the employee's reasonable expectation of privacy. And again, this is true for government employees. It's even more true for private sector employees. If the employee has been told your locker is not private, the employer has the locker combinations for all the lockers. Then under those circumstances, the employee doesn't really have a reasonable expectation of privacy for the lockers or the computers. Um, the Fifth Amendment is also an area that we see privacy expectations arise. Let's just pop on over there for a second. Here's the Fifth Amendment, and we have the due process situation. Here is it. No person shall be compelled in any criminal case to be a witness against himself or be deprived of life, liberty, or property without due process of law. So we're really focusing upon um, uh, property without due process of law. And government employees do sometimes have a property interest in their employment. It's an income stream for them. And so due process of law can have a role in privacy determinations, again, where the person is a government employee. Um, we also have the 14th Amendment. The 14th Amendment is the vehicle through which not all, but many of the rights afforded us in the Bill of Rights, the first 10 amendments, afforded the protections we enjoy against the federal government. Through the 14th Amendment, they start applying to state government action, and via state government, also local government action. Not all the protections we enjoy in the Bill of Rights do apply to state governments, but many of them do. And so let's see where we see that protection come up. So in the 14th Amendment, the 14th Amendment is a long one, we see it come up in two places. Here, nor shall any state deprive any person of life, liberty, or property without due process of law. That's the due process clause of the 14th Amendment. Then the next part is nor deny any person within its jurisdiction the equal protection of the laws. So those two protections extend those privacy rights that we were talking about under the Fourth and Fifth Amendment. It applies it to state and local governments. And so state and local employees are thereby given these protections. So under the Fifth and 14th Amendments, we see that due process idea. The government has to decide kind of what the level of review is going to be for due process rights, because that's a pretty open-ended, pretty broad concept. So how closely or how much are we going to micromanage what due process means with state and federal governments? And we see there's actually three levels, but we're just going to talk about two of the levels here. And one is strict scrutiny. This is when the courts are really going to put a lot of onus or a lot of review of that governmental action. And if the court system finds that it was overreached, they're going to say, nope, that was too far. And so we call that the strict scrutiny standard. And this applies to fundamental rights. Remember we had the word fundamental rights earlier? This is where we're actually going to be using that term again. We had that when we were talking about the reasonable expectation of privacy. So fundamental rights requires a compelling state interest justification. So before um, the, uh, the federal or state government can interfere with a fundamental right, it's going the state or federal government have to prove a compelling governmental interest. This is a very high hurdle. Usually, this isn't very successful. And we can see that a fundamental right can be at play with privacy. We'll talk more about that later on in this presentation. If the right isn't a fundamental right, the hurdle that the government has to overcome is significantly smaller. This is the lowest standard. We're not going to talk about the middle standard because it's not really relevant in this analysis. But this can be if the search was rationally related to a valid state interest. So obviously you can see that it's really important whether, if we're talking about government employment, whether we're talking about this high hurdle strict scrutiny or the rational basis low hurdle. Because honestly, if it's this hurdle, it probably means the employee has a pretty good chance of prevailing. If this is the hurdle, it almost certainly means the employee is going to lose. So this is the most important part of the analysis when we're talking about government employment and privacy is, are we going to apply a strict scrutiny standard or are we going to apply the rational standard? And again, the question is the right fundamental? That's what this analysis turns on. And here we're looking at, is it implicit in the concept of ordered liberty? Do we have to have this to be a free society? Is it also deeply rooted in our nation's history and traditions? Okay, well, at this point, I'm going to leave it a bit on a cliffhanger. We're going to talk about what this means in terms of constitutional analysis in our next video. I hope that if you found this information interesting and helpful. As always, if you have questions about the material, please don't hesitate to stop by my office hours so we can talk about it in more detail. Thanks so much for your attention and have a wonderful day.